Why?
Well, we got the blood discovery back, and so she doesn't want to pursue the trial. We need to hire an expert. So, but it's gonna have to come down to 5 hours.
I mean,
The problem is she's not in probation because she's already completed on the federal case. So she already doesn't have, I mean, it's like,
was
it made it really
correct?
hard. I know. I'm not gonna get us to that other thing.
Can you not, wait. Why are you saying she's not probation eligible?
I mean, obviously.
You'll notice the judge's efficiency throughout these consecutive hearings. This is part of a docket management style that balances fairness with the practical need to keep proceedings moving. It's a skill developed over years on the bench, handling a high volume of cases without sacrificing due process or individual attention. You can also see how even seemingly routine paperwork carries long-term consequences. For example, on probation or related disclosure forms, a defendant may be required to acknowledge prior convictions, including federal offenses. That's why judges often stress that courtroom decisions do not end with the hearing itself. The legal and personal consequences can continue long after the sentence is imposed.
I'll make you a deal, Mr. Katan. If you do really well, if you're nice to everybody, you get your stuff done quick, I'll take you off in half the time. You could be done with this thing in a year if you get everything done, don't test positive, and most of all, just be nice to everybody. It's not hard. You get upset, someone pisses you off, walk away, find another release. Because, well, time will tell. Actions speak louder than words. Everybody tells me that. Really. How do you plead to the offense? Guilty or not guilty? I'm not going to find you guilty. I will withhold that for 2 years. But like I said, get it done quick. We'll take you off quick. What do you do for a living?
Right now, I'm not able to work because I had this open 2 cases managing Airbnb.
Is there another case that's getting dismissed as a result?
There's 2 felonies that are being dismissed, right?
Wow. You also need to realize this is that there's only so many times in life that DAs are going to also help you out, because that is a hell of a deal that they're doing now. I mean, you work some kind of magic. They're going to dismiss an aggravated assault and an injury to a child. You're pleading to this. That is a hell of a deal. Things like this don't happen all the time. So if it continues to happen, get ready.
Notice how the tone remains steady even as new cases cycle through the docket. That consistency is part of maintaining order and clarity in a busy courtroom environment. Each defendant's acknowledgement and participation are important procedural steps. Failing to respond, failing to appear, or remaining absent without authorization can lead to additional consequences, including the possible issuance of a warrant. It's moments like these that highlight how courtroom decorum is tied not just to formality, but to the practical functioning of the judicial process itself.
I don't know anything about the case in North Carolina.
Well, they said that, didn't you say that, Amy, there's a hold in North Carolina, or he's wanted out of North Carolina as well?
That's what Nicole said. Did come up. I actually can't.
Okay.
Right now, so.
I gotta wait for Day to come up.
Okay.
Oh, hi, Josh, come on up.
I had Vincent Rodriguez on docket and he did not appear, Judge.
How come?
I lost contact with him. The number is disconnected.
Oh, isn't he in jail?
No, I don't know. So.
Oh, this is a different one. Okay, so, God, this is an old case. Okay, so I'm gonna set it at 5,001. Yeah, and then just, you want to withdraw or do you want to stay on?
I'll stay for now.
Okay, all right, just let us know. Okay. You saw that? On Rodriguez, yeah, 5,001.
Oh, okay.
On Vincent Rodriguez. Mr. Broussard.
Sure.
Hey,
Quick question.
shoot.
Just here this morning for Jose at his office.
Okay,
Steps we did the both cases. He's got bond. Yes. Some point I guess need to be addressed.
is he in jail or
Yes.
he's in custody? I didn't realize that, sorry.
And to my knowledge, Judge, felony is planning on filing an 11B upstairs.
That's next stop at 179.
What would you like?
Well, my question is, I'm going to the 179 and see if that is accurate, because I haven't seen an 11B hit the system yet. I'd like to talk about his felony bond situation up there so I can have some more clarity on what.
As we move deeper into the docket, the judge's cadence begins to set the rhythm of the courtroom. Calm, consistent, and controlled, it reflects the structured nature of judicial proceedings. Whether the matter is a misdemeanor update or a felony review, each defendant receives the same measured attention and procedural clarity.
Then I'm good. I am unopposed to both of those. Rolling it over for the no bond, and if
No. I'm saying, but I mean, what sense is there in rolling it when?
Oh, I thought that was.
Yeah, I mean, if you want me to, Chablis, I will, or we
No,
can't.
Judge, I would prefer
but-
that you talk to him today. What he was trying to tell you was that about the lawyer and that he already had that secured. And I explained to him that I don't believe that that would make a difference because of the pending case in North Carolina as well as Tennessee. If you could admonish him and tell him that, then we may not
Sure.
have to come back tomorrow.
Understand that don't matter whether you come back tomorrow, next week, 2 weeks, you have a lot of baggage. You've got this, you now have an open theft from an elderly of $150,000 to $300,000. You've got the same 2 cases in Tennessee. You also have a hold out of North Carolina. I'm not going to set you a bond. It's just way too much baggage. And you scare me, quite frankly, you know? Don't say anything. It doesn't require. I get it that you have a lawyer over there. But the deal is this, is that if you truly do have a lawyer there and you're able to, somehow your lawyer is able to work where they release the holds over there, like you're able to post bond in North Carolina, you know, that would release the hold here.
I didn't know about the case in North Carolina until just now. Didn't know anything about it.
Well,
So that came this morning, Judge. When I was talking with the state earlier, they said, FYI, that there's a pending hold in North Carolina. So when I spoke with Mr. Hunter on yesterday, neither one of us was aware of the North Carolina case.
And that's okay, but we're letting you know now that there's a lot there going on. And so if you have a lawyer and your lawyer is able to work Tennessee as such that they can release the holds, then that would release the holds here and you're able to post bond on your case here and then you're out. But I don't feel comfortable giving you a bond knowing that you're wanted out of 2 different jurisdictions. What you're wanted for in one of those jurisdictions is the exact same case that you just picked up 3 days ago here.
It's the same people.
Well, I don't know.
It is.
I know that.
I have the documents.
I'm not here to litigate your case. I'm only here to give you a heads up that I don't feel comfortable giving you a bond. That's it. The more baggage you come here with, the higher, just it's not going to happen. So wanted to bring you out to let you know whether you come back tomorrow, whether you come back next week, the answer is just not going to change. You know, my primary concern is the protection of my community, and I'm going to do it at all cost. That's it. Now, Mr. Hernandez, you got to understand, I set your bond, I've cut it in half from the other case, but you have to understand that you are an inherent flight risk. So before I sign your waiver withdrawal, you need to understand that on fugitive cases, you're not going to get the 10% where you're going to have to pay $2,500 and you're going to get out. It's a fugitive case, so you are a flight risk. So you probably will have to pony up most, if not all, of the bond to be able to make bond in this case. Do you understand?
By now, the rhythm of the hearing becomes almost mechanical, but that's often the hallmark of a well-run courtroom. It reflects precision, order, and respect for the record. These closing moments highlight the quiet strength of procedural justice, steady, impartial, and deliberate in its application.
Do you have the ability to get back to California once you get out? Okay, you have someone that's you can't get on a plane, try to get on a plane, it's probably not going to go well. So you're going to secure some other kind of transport to get back to California. Yeah, sure. But understand that we only give you 2 weeks from the date of your release to do that. If we call in 2 weeks and nothing has happened, you've not turned yourself in, or you've not posted that $50,000 bond, I'm going to revoke this, set it at 0. All that money's gone, and you're going to be in here again, and I won't do this again. Do you understand? Okay. Day, did you have anything that you wanted to add?
No, I'm just drafting the reset for the defendant to sign. I got the withdrawal waiver from counsel, which I just printed out. Did you want defendant to come back out for admonishment for the
No,
signature?
no, no. That's why I'm letting him know now. That way we can take care of everything at one time. Shabli, is there anything that you wanted to add?
I just want Mr. Hernandez to know, so I've already signed the motion to withdraw the waiver of formal extradition. So that means that if your family doesn't make the bond for another 5 days, then you've essentially lost the 7 days. You understand that?
Yes, ma'am.
Okay.
He withdrew 7 days ago?
No, I'm saying if he sits there for 5 days and he
I
signed it
see.
on
Got it.
yesterday.
Right. Right. So because you are going to withdraw this waiver, if you're not able to make that bond, you're going to have to waive again. And then you're going to be sitting for another 14 for California to come get you. You understand this? Okay. All right.
It's gonna be reset to February 13th for Hernandez.
That's the, do you need me to
Thank you,
sign
thank you. Sorry, one's for the court, one's for the.
That's where you're sitting right here.
This is to the, this is to judge. Yeah, thank you.
Oh, here it is. Sorry. I thought I signed it. All right, guys. I wish you the best of luck. Good luck. Good luck.
Thank you, Judge.
Thank you, Judge.
Good morning, Mr. Nguyen.
For a plea.
Good morning. Why don't you ever show up to court? You know, if you show up to court, good things happen. We can give you whatever you need. You want a cell phone, tablet, food to eat, a place to stay? We can get all these services to you if you show up. You're charged with 2 cases. You're charged with theft. You're also charged with criminal trespass. You've worked out an agreement where they're offering you 7 days in jail, credit for the 7 days that you've done on the theft case. You need to understand that this now makes 1, 2, 3, 4, 5, your sixth theft case that will now end up in a conviction. You need to understand a third is usually they will file a felony on you. And I don't know why it's happened, but at some point you're going to get a rogue, or not a rogue, but you're going to get a prosecutor that hits you with a felony. And then you're looking at years instead of days. You understand? You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you cannot change this. Do you understand? How do you plead to the offense of theft? Come back. If you pick up a criminal case, come to court. We will help you. All right. Good luck, sir. I'll find you guilty, sentence you the agreement. Thank you, sir. All right. If it's enhanced, it'll be abandoned.
Excuse y'all.
Thank you. Thank you.
State your, for plea.
Morning, Mr. Brennick. You're charged with 2 counts of trespass. You're also charged with 1 count of interference with the duties of a public servant. You've worked out an agreement. They're offering you 15 days in jail with credit for the 5 days that you've done on one, and they're going to dismiss the other 2 cases. Is that how you understand it?
Yes, sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, this will go on your record. You have to understand from now on, you're facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand?
Yes, sir.
If you show up to court, good things happen. We can give you whatever you need. You want cell phone, tablet, food, a place to crash. If you come back, we can give it to you. If you don't come back, this is eternally what's going to happen. You pick up a new case, come back. All right. Good luck to you, sir.
Thank you, Judge.
Oh, because it must be anti-theft. Anti-theft. Yes, so we'll reset to.
Yeah, for sure.
The first one is 2, 8, 6.
She just got placed on probation. She did have TRS. She hasn't had any like violations on her device since November, but the TRS recommended community residential. She's currently on a high-risk caseload and is doing IOP and SOP. So they're asking if you can use the residential distinction.
I think so.
Okay. The next two are expiration staffing, so their probation is about to expire and they
Yep.
still have stuff to do.
Okay,
The first one is 242-0858. He's currently enrolled in a DWI intervention program and is not expected to complete it until March. He's on probation until March 17th, so they're just asking for a 2-month extension just to make sure he can get the certificate.
okay.
No, that's one else.
And then this last one is 249-6906.
Yeah, that's why.
They're asking for a 4-month extension on this one. He's completed IOP, he's currently enrolled in SOP, but he also has to complete the victim impact panel and the DWI intervention.
He hadn't done it and it's been a whole year. No, court admonishment. This is his third DWI.
Okay. I'll have to come on Friday.
Yeah.
Yes.
No.
Are you feeling better?
Great. Thanks.
Judge, council's approaching for page 10.
Hi.
Ludlow?
Good morning, Your Honor.
Hey, what's up, Joe?
This is one where we needed an additional time in order for the client to complete the anger management class and community service hours. My understanding from the office was that he had gotten the flu and was ill. I think everybody's got it. I had it too, just got over it, but that was going around. But due to the age of the case, the coordinator wanted me to approach. I did discuss with the.
What has he done, if anything?
Well, we believe that he's got some of the community service hours. I don't have the complete 30. I think she told me today it's 30.
I just saw him here.
We have no proof of any.
He's here.
Service hours, but we do have him, he did the decision-making course.
Okay.
Let me,
And- oh, I saw him.
I'll get an update for you so you know exactly what he's got, okay? Give me 1 minute.
How are we looking, Victoria?
This please the last thing. This please the last one.
Nice. Well, Cortez is on bond plea.
Yeah, that's what they're doing now.
Tanya Broholm said she wants to plead Manera, who's in the